Hello everyone, and thank you for participating in the Adult Protective Services Basic Skills Case Decision, Mobilization, and Planning Webinar 404. My name is Denise Leake, and I work for the Division of Aging and Adult Services in North Carolina. I'm the Adult Program Services Consultant for the state, and I travel across North Carolina providing trainings and presentations. This webinar will cover the following topics: review of APS evaluation, review of determining capacity, planning and mobilization of services, obtaining legal authorization court-ordered, authorization including conflicts of interest, day sheet coding, steps in closing an APS case, and APS record. First, I'd like to review the Family Assessment and Change process. In the first three APS Basic Skills webinar, we've covered reviewing and screening the referral, evaluating the need for protective services, and now we're going to look at obtaining service authorization and planning and mobilization essential services. The webinars have taken us step by step through the Family Assessment and Change process. At this time of the evaluation, all 6 functional domains have been evaluated, and it's the time to make a case decision using the following 3 criteria. Is the adult a disabled adult? Has there been maltreatment? Are they in need of protective services? If the answer to the 3 criteria is yes, then the need for protective services is substantiated, and the next step is to determine capacity of the disabled adult. The type of appropriate authorization is determined based on the capacity of the disabled adult. Once the capacity decision is made, appropriate authorizations must be obtained. If a person expresses knowledge in the following 4 areas, he may have the capacity to consent to protective services: awareness of limitations and/or deficiency in his or her environment, awareness of his or her own mental and physical limitations, awareness of resources available to assist in meeting his or her needs, and awareness of the consequences to him or her if nothing is done to improve or remedy their situation. If it is not clear that the person is knowledgeable in all 4 areas, further evaluation by a psychologist, a physician, clinical social worker, or other appropriate professionals may be necessary in order to help determine whether or not the person has capacity. Even if an expert evaluation is obtained, the Department of Social Services is ultimately responsible for making the decision about the adult's capacity to consent. Once a decision has been made about the adult's capacity to consent to protective services, it should be documented carefully using the case finding section on the APS assessment tools. Be sure to describe the adult's perception of his or her situation, his or her perception of the consequences of their situation, and the impairment or incapacity which makes the adult unable to make and/or communicate reasonable decisions. In a written description, reference any areas of the evaluation that provided more details. Clear, concise, and thorough documentation of capacity to consent is important in all areas. The capacity decision should be documented using the Attachment A, Determination of Ability to Consent to Protective Services form. This form is used to reflect why or why not an adult has capacity to make decisions regarding protective services. It is an opportunity to showcase capacity or lack thereof and document concrete examples. This is the Attachment A form, and social workers are asked to fill out all areas, sign, and date it. Once the evaluation has been completed, the case decision is made, and the capacity of the disabled adult has been determined, authorization for services must be obtained. There are different ways to obtain service authorization. The client has capacity to consent to services. The adult has a legally appointed guardian, or the person, guardian of the estate, or general guardian. The adult has a power of attorney, or court-ordered authorization has been obtained. The first decision we will look at is if the adult has capacity and consents to protective services. 108A 104, provision of protective services with the consent of the person, withdrawal of consent, caretaker, refusal. If the director determines that a disabled adult is in need of protective services, he shall immediately provide or arrange for the provision of protective services provided that the disabled adult consents. When a caretaker of a disabled adult who consents of the receipt of protective services refuses to follow the provision of such services to the disabled adult, the director may petition the court for an order enjoining the caretaker from interfering with the provision of protective services to the disabled adult. The petition must allege specific facts significant to show that the disabled adult is in need of protective services and consents to the receipt of protective services, and that the caretaker refuses to allow the provision of such services. If the judge finds by clear, cogent, and convincing evidence that the disabled adult is in need of protective services and consents to the receipt of protective services, and that the caretaker refuses to allow the provision of such services, he may issue an order enjoining the caretaker from interfering with the provision of protective services to the disabled adult. If the disabled adult does not consent to the receipt of protective services, or if he withdraws his consent, the services shall not be provided. If the adult consents to protective services, thoroughly reviewed the essential services needed, documented the acceptance of protective services on the attachment A form and are in the narrative, the adult will sign and date the 5027 showing their agreement to serve, and the adult will receive a copy of the 5027. That includes the rights and responsibilities on the carbon copy form that will be the blue copy, or equivalent form if your agency has electronic forms. Once services are authorized, plan and mobilize the services with the adult, complete the service plan with the adult, and send required notices to law enforcement, district attorney, and others if appropriate, and the reporter as they requested, whether verbal or written letter. Then move forward with the provision of essential services. If the adult has capacity but refuses to consent to protective services, then document the offer of protective services and the adult's refusal. Next, fill out the attachment A form, make the appropriate referral to the community, close the case with appropriate notices to the reporter, district attorney, law enforcement, or other as may be required. Complete the 5026 and 5027. Social workers can not put services in place without the adult's consent. If the adult has capacity, and should completely explain and explore services with the adult. If the adult lacks capacity and the case decision substantiates the need for protective services, then protective services must be provided. However, only a legal authorized guardian or doable power of attorney can consent to protective services. If no legal authorized person is available to consent or to decline the provision of protective services, then legal authorization must be obtained in another manner before protective services can be provided. If a surrogate decision maker is in place and accepts protective services, the agency must provide clear documentation of their authority as well as a written statement of the consent to protective services signed by a surrogate. It's recommended you have your agency attorney review the documents to assure that authority the surrogate decision maker may or may not be granted. A copy of the power of attorney or letters of guardianship should be included in the record. If it is determined the decision maker has appropriate authority, they may sign the DSS 5027 to consent by mobilization of services. Open Service Code 204 on the 5027 and have the decision maker sign and date the form. A copy of the signed 5027 and consent to services shall be provided to the decision maker, which includes a copy of the rights and responsibilities, i.e., the blue copy or equivalent. If the adult lacks capacity to consent to services and there is no legal authorized person available to consent or decline the provision of protective services, legal authorization must be obtained before protective services can be provided. It may also be necessary to petition for removal of a legal decision maker if they are the perpetrator. There are times that adults, due to disability, are no longer able to manage their personal or financial affairs. In the next few slides, we will review a range of court orders that will be used to provide authorization for protective services. Each has a specific purpose and is only appropriate under certain conditions. General guidelines for preparing petitions. The petition should support each element with specific facts, not the social worker's opinion. The social worker should provide clear, concise, and factual information to the attorney as he or she can easily write the petition. If the agency attorney is not the person who prepares petitions, he or she should review them before filing. For example, a statement such as, "The house is dirty," is not adequate. A better statement would contain more detailed information, such as, "Miss X, who is barely able to walk, is living in a house with rotting floorboards and broken outdoor steps. She is unaware about how she would get out in case of emergency. She also leaves newspapers and clothing near the kerosene heater and doesn't recognize this as a potential fire hazard. She has a strict regimen of medications for diabetes and hypertension, which she is unable to self-administer on a routine basis." The different types of protective service orders that the DSS can petition the court are: order authorizing protective services, order authorizing emergency services, and ex parte order authorizing emergency services. The DSS should consider the adult's condition and circumstances in determining whether it would be more appropriate to petition the court under the Protective Services Law or guardianship law. Each protective services order has specific criteria for when it is appropriate to use. For example, if a case is unsubstantiated, there would not be a need for protective services order because there is no need for protection identified during the thorough evaluation. However, there may be a need for guardianship proceeding during the APS process. This slide shows a copy of the petition for ordering authorization protective services. Let's take a look at the petition for ordering authorization protective services. Our North Carolina state policy states, in preparation to petition the court for an order authorizing the provision of protective services, the worker must document the facts which shows that the disabled adult is being abused, neglected, or exploited, and the adult lacks the capacity to consent to such services. The court will schedule a hearing within 14 days after the petition is filed. The disabled adult must receive at least 5 days' notice of the hearing. He has a right to be present and represented by counsel at the hearing. If at the hearing the judge finds by clear, cogent, and convincing evidence that the disabled adult is in need of protective services and lacks capacity to consent, he may issue an order authorizing the provision of protective services. The order may include the designee of an individual or organization to be responsible for the performing or obtaining of essential services on behalf of the adult, or otherwise consenting to protective services for his behalf. Within 60 days from the appointment, the court will conduct a review to determine if the petition should be initiated in accordance with the GS 35A. For good cause shows, the court may extend the 60-day period for an additional 60 days. The APS statute does not require notice for the filing of a non-emergency petition to be given to anyone except the adult. It is good practice, however, to notify the adult's spouse, children, or next of kin and guardian, if any. An example of when DSS would petition for an order authorization protective services is when an adult protective service evaluation has been completed and the case decision is substantiated. It has been determined that the disabled adult lacks capacity to make decisions. The adult is diagnosed with heart problems and severe arthritis. This adult has lived at the same residence his entire life. Unfortunately, the home is desperate need of repair and he has no one to help him with maintenance of the home. In this example, there is no immediate danger of the adult's health and safety, so DSS would petition using the order authorizing protective services. Once the order is granted, the DSS now has authority to move forward with obtaining appropriate housing for the adult. While pursuing housing, the DSS will continue to make frequent contacts with the adult to ensure he is safe and his needs are met. If the court does not grant an order authorizing protective services, the agency have no authority to continue working with the disabled adult and must close the case for protective services. An emergency order should be obtained when a disabled adult lacks capacity to consent, is in need of protective services, an emergency exists, and no other persons authorized by law or ordered to give consent for the disabled adult is available and willing to arrange for emergency services. Emergency services are services necessary to maintain the person's vital functions and without which there is reasonable belief that the person would suffer irreparable harm or death. This may include taking physical custody of the disabled person. This could be found at General Statute 108A, 101H. Petition for emergency protective services. When preparing a petition for emergency order which involves a medical crisis, it is very helpful to have a statement or affidavit from the physician which explains the nature of the emergency, the danger and the delay, and the treatment needed to alleviate the crisis. This statement should be as detailed and specific as possible. The purpose of emergency services should be services necessary to maintain the person's vital function and without which there is reasonable belief that the person would suffer irreparable harm or death. This may include taking physical custody of the disabled adult. Notice of filing of the petition and other relevant material must be given to the adult, his spouse, or, if none, his adult children or next of kin, and his guardian, if any, at least 24 hours before the hearing. A hearing will be held, and the court may order the emergency services necessary to remove the conditions creating the emergency. If an order authorizing emergency services is granted, an agency has the authority to enter the disabled adult's home without his consent if necessary to provide essential services. Order for emergency protective services. The court will order only the services necessary to remove the condition creating the emergency. If services are needed for more than 14 days, the agency should file a petition authorizing protective services. If an order authorizing emergency services is not issued, protective services must be closed because the agency has no authority to continue its intention. An example of when to petition for an order of emergency protective services is when you have a disabled adult who lacks capacity and has no one legal authorized by guardianship or power of attorney to obtain essential services. The adult lives alone and has dementia and mobilization difficulties. Finding all the thorough evaluation included that the adult was not eating, was not bathing or wearing clean clothes, was not taking her medication, was not falling frequently, and was not seeing her physician regularly. There is a niece that lives out of state who is willing to stay with the adult 9 days but then must return home, leaving the adult alone. Since the case decision determined the adult needs protection when she is alone at home, the need for protection will return when the niece leaves. For this reason, once a case decision and capacity decision is made, DSS would immediately petition using the order authorizing emergency protective services. Unfortunately, since the niece who is able, willing, and responsible is the home and is providing care for the next 9 days, the DSS will need to move quickly to secure essential services to provide protection within 9-day time frame so the disabled adult is not left in an unsafe situation. Order authorizing emergency protective services ex parte. The length of time for which the adult can go without service or treatment is a primary factor in determining whether an ex parte order should be requested. If death or irreparable harm is expected to result within 24 hours unless services are provided, it is appropriate to request an immediate emergency order ex parte. Another consideration is the length of time required by the local court to schedule a hearing and petition for an emergency order, which varies from court to court. When authorization of services can't wait 24 hours, the judge may authorize services ex parte. Emergency ex parte orders are issued immediately without notice to anyone and without the opportunity for all sides to be represented. Here is an example of ex parte situation. A disabled adult who has had a CVA and has been lying on the floor for 2 days. When found by a neighbor, EMS was called, but the adult refused transport, although his life was clearly in danger. He is confused, unable to get off the floor. He has not eaten in 2 days nor taken his medication. He does not understand the risk of refusing transport to the hospital or how serious his condition is. He is clearly a functional disabled adult who is self-neglecting and in need of protective services. A substantiated APS case. He lacks capacity in not understanding his condition or needs. Due to the urgent situation which could quickly result in his death, an ex parte order is filed to allow entry into his home and to take him into the hospital for life-saving treatment. Guardianship may be appropriate for adults who are incompetent and vulnerable to abuse, neglect, and exploitation because of their inability to make reasonable decisions over a long period of time. Guardianship may be an appropriate alternative to court action under the Protective Services Law for an adult who is incompetent and whose incompetency results from a condition which is long-term and unlikely to improve. The adult has income which needs to be protected and cannot be managed by a payee. The Protective Service Law does not provide a basis for anyone to assume control over an adult's financial resources. Funds cannot be managed, for an example, under an APS order, but can be by a guardian, or there is property that needs to be protected and are managed. An interim guardian can be appointed if there is reasonable cause to believe that the adult is incompetent and there appears to be an imminent or foreseeable risk of harm to the adult's physical well-being or state which require immediate intervention. This is a copy of the petition for adjudication of incompetency and application for appointment of guardian. Service authorization involving conflict of interest. The DSS conducting the evaluation will seek authorization for services, including petitioning the court in the county of residence if necessary. The petition must include the reason why the petition is being filed by a county other than DSS in the county of residence. The county of residence is responsible for all expenses incurred during the course of the evaluation. If the case decision is to substantiate the need of protective services, the agency that conducted the evaluation will seek authorization for services, including petitioning the court when necessary. The petition shall be filed in the county of residence and shall include the reason for filing by an agency in another county. The agency will conduct the evaluation, will act as case manager for protective services in conjunction with the agency in the county of residence. The county of residence will be responsible for paying for services and for paying for an expense for medical, psychological, or other examinations and legal services incurred by the county which conducted the evaluation. Let's do a recap of service authorization. If the adult has capacity to consent and agrees to services, then your agency immediately provides and arranges services for the adult and completes a case plan with the adult and whomever they want to be a part of that case plan. If the adult has capacity and refuses services and services are not provided, then the contact is terminated. Be sure to document why the adult is refusing very clearly. If the adult lacks capacity to consent, then legal authorization is required before services are provided. If legal authorization is necessary to provide protection, it should be pursued quickly. Social workers may need to talk to your supervisor to get a protection order, or if there is a surrogate decision maker like a POA or guardian to obtain service authorization. Different types of orders that are available with the court action are an ex parte order, emergency protective services order, and protective service order, interim guardianship, and guardian of the person. Services should be provided without delay. The services are used to stop maltreatment, and the disabled adult should not be left without protection in place to stop the maltreatment. When DSS decides to petition the court for guardianship rather than obtain an order to provide protective services, 202 should remain open until authorization to provide protection services is granted. All activities, including filing the petition, the hearing, the court case decision, should be coded to this code. Service Code 107 guardianship can be opened. However, all activities on the day sheet up until the court makes the decision should be coded to 202. Once the authorization determined is made, 202 can be closed. Since the case has been substantiated, the Service Code 204 should then be opened on the 5027. The definition of Service Code 202 includes obtaining authorization from the court. The definition states evaluation includes making the case decision, determining capacity consent, and activities related to obtaining service authorization either from the client or the court. It includes the service of lawyers to represent the agency where court action is necessary to provide the adult. When an APS petition has been filed, it includes the time until court authorization is obtained.
Planning essential services. The following points should be considered when developing APS service plans. The plan should flow with the evaluation. Significant problems or needs identified in each functional area during the evaluation should be identified in the checklist for change and addressed in the service plan. The essential services utilized should fit the client's situation. Client and family strengths and goals identified in the evaluation should be taken into consideration as the plan is developed. For example, just because Meals on Wheels is available, it should not automatically be used with every client over the age of 60 if you can find another alternative. Remember, the least restrictive tenant. The plan should be developed in collaborating with the client and family. Family is defined by the disabled adult and may include individuals that are not related by blood, who are important to the adult, as well as individuals that are related by blood. The client and his or her support system should participate in identifying areas for change and goal settings as much as possible. The client and the client support system should always be involved in implementation of the service plan. The family and other informal support systems should be preferred service providers. A wide range of services should be considered when developing an APS service plan. Services which can be used are limited only by the resources of the client, family, and community. Services can be delivered in a variety of settings, including long-term facilities as well as community-based settings. Adult protective services should be a shared community responsibility, including services from other agencies in the plan as much as possible, and involve other community professionals in developing of the plan. Use of multidisciplinary team to develop and implement a service plan is ideal.
This is a copy of the service plan. The client or their authorized representative should sign and date the service plan and receive a copy.
There is a service plan webinar on our website that we encourage you to go watch.
After the service plan has been developed, it is necessary to monitor the service plan to ensure goals are being accomplished and that the adult is being protected. Social workers should constantly be reassessing the adult situation and updating the service plan as needed. Monitor the service plan to ensure the adult's needs are met and the need for protection is no longer existing. Do regular visits with the adult, and during the visits, monitor the service plan to ensure that the adult has adequate protection. Stay in contact with the service providers that provide essential services to the adult. Ask service providers if the adult is following through with the plan, such as are they going to the doctor's appointments, taking medications appropriately. Ask the adult if the services are meeting their needs or if adjustments need to be explored. Part of providing protection often involves collaborating with community partners. Collaborating is defined as follows: when different professionals possess unique knowledge, skills, organization perspective, and personal attributes, engage as coordinate problem solving for a common purpose. Assuming complementary roles is working together, sharing responsibility for problem solving and making decisions. We highly recommend multidisciplinary teams in your agencies. The development and supportive team approach should also be encouraged by the agency. The agency may want to develop their own APS multidisciplinary team. This team approach helps agencies coordinate services, reduce duplicate of services, provides a means of share clients' information and several other professionals in the community, and have the benefit of others' knowledge, experience, and expertise in developing service plans and resolving client problems. The School of Government has resources on their website on developing a multidisciplinary team. Community partners could be law enforcement, DA, mental health, public health, Office of Aging, hospital, homeless shelters, and faith-based agencies. There are probably more other partners you know about that are in your specific community. It is important to work together in accomplishing specific goals.
Questions to consider when you're making the decision to close the APS case. Is there still a need of protection? Is the risk resolved or reduced? Has the service plan been completed? Have the safety issues been resolved? Did the client refuse services? Was the client referred to other providers? Did the client move out of jurisdiction? Is the client deceased and/or is the agency unable to locate the adult?
Before closing the case, monitor the plan to ensure the case plan has been completed and there is no longer a need of protective services for the adult. By visiting the client in their home, if the plan has provided the necessary services and there is no longer a need for protection, then discuss with the adult that services are in place and the case will be closed or transferred. The APS case is terminated and the client is given a 10 working day notice of termination. The APS case can be closed if the client that has capacity refuses services. If the disabled adult is capable of making a responsible decision and refuses the receipt of protective services, the worker must respect that decision and terminate contact with the adult. Prior to doing so, the worker shall explain the services available to the adult and that the adult may call the agency to request assistance if needed. Documentation shall be made of the worker's explanation and offer of services and of the adult's refusal to accept or continue services. The worker shall obtain from the adult a signed statement of his refusal of services or shall document in the record the attempt to obtain such signed statement. Other reasons for closing the APS case include the client has been referred to other providers or the client has moved out of the county. Examples of referrals to other providers or services include, but is not limited to, SA in-home, mental health services, personal care services, in-home aid services, or home-delivered meals. If the client moves to another county during mobilization of services, North Carolina Administrative Code 10A NCAC 71A states the following. If a disabled adult who moves to another county has consented to the provision of protective services and no court order is involved, the county department providing protective services shall ask the disabled adult to consent for information to be shared with the department in the new county of residence. If the adult does not consent to the department providing protective services, shall not share information with the department in the county of residence. If the adult consents, the department shall notify the department in the new county of residence of the disabled adult's situation. The department in the new county of residence shall contact the disabled adult to determine whether or not protective services continue to be needed, and if so, if the disabled adult consents to their provision. If the department in the original county of residence has been providing protective services under a court order, the department shall file a motion in the court to be relieved of responsibility because the disabled adult has moved to another county. The department shall make a protective service referral to the department in the new county of residence. The department in the new county of residence shall evaluate the adult's current situation to determine whether or not protective services are needed, and if so, shall request authority to provide services. If you are unable to locate the client, then the case may be closed after making diligent efforts to locate them. Diligent efforts would include contacting law enforcement, hospitals, talking to their primary care physician, visiting the last known address and location, or address at a different time of the day, on different days, talking with neighbors, families, or other collaterals, checking homeless shelters, and I'm sure you can think of many other places in your community. Documentation shall include all the diligent efforts made to locate the adult. When closing the case, complete all documentation. Documentation should be up to date, clear, and thorough. The documentation must include how the goals on the service plan were completed and the need for protection no longer exists. It's imperative that the case documentation tells the story from intake to case closure. It must be written in a manner that anyone could read the case and follow the sequence of events or efforts made throughout the case. North Carolina Administrative Code 10A NCAC 71A requires that a written report be completed after the completion of evaluation and sent to the appropriate entity when the Adult Protective Services evaluation was conducted on a patient or resident of a facility, evidence of abuse, caretaker neglect or exploitation is found, or evidence of financial exploitation is found in Medicaid-funded facilities. The written report may not include the name of the reporter or collateral contacts. It may be used to provide information about the results of the APS evaluation to various entities which may require this notification. Some examples of the use of this form include, but are not limited to, notifications to the district attorney and law enforcement, notifications to the Secretary of State's office, notification to the Division of Health and Services Regulations, notification to the Division of Health Benefits when evidence of financial exploitation is found for an adult residing in a Medicaid-funded facility, notifications to government officials, agencies such as Social Security or Veterans Administration when an APS evaluation indicates violation of applicable statute, rules, and regulations. Contents of a written report should include the name, address, age, condition of the adult, allegations, a summary of the evaluation to include findings and supporting documents, conclusions, and recommendations for actions. When closing your APS case, the 5026 must be completed and keyed. The DAS 5026 is used by county staff to enter APS data in the XPTR for the Adult Protective Services Registry. The DAS 5026 must be completed on all Adult Protective Services reports received and evaluated by DSS. The form must be completed and keyed within 10 working days for the case decision has been made. The social worker or data entry staff should document the data, the date the information was entered in the system. The APSR manual may be found at the web address provided on the PowerPoint.
This is a copy of the 5026 form.
The last task to complete in closing the APS case is to close the 5027. Everything should be completed prior to keying the 5027. Information on closing the 5027 is found on the North Carolina requirements for the provision of services of County Department of Social Services. The web address is provided on the PowerPoint. This is a copy of the 5027 form. There is a 5027 webinar on our website that will give you details on how to fill this out. I like to review the SIS codes that will be used on day sheets during APS process. Code 200 is the code used for protective services for adults. Intake means receiving and documenting information which alleges that the disabled adult has been abused, neglected, or exploited and is in need of protective services. Intake activities include making a decision regarding the information being provided to determine whether protective services evaluation will be initiated, noticing the reporter about whether the information has been accepted for APS, directing the reporter to another agency or other community resources when appropriate, making referrals to the district attorney, law enforcement, and or other regulatory agencies when appropriate, and completing thorough documentation of the above activities. If the report is screened in for evaluation, then 200 code is opened on the 5027 and used for the day sheet. 202 is used throughout the evaluation. This code means conducting activities necessary to determine whether a disabled adult has been abused, neglected, or exploited and is in need of protective services, and to assess what services are needed to prevent further mistreatment. Unsuccessfully, efforts to locate the adult are included as part of the evaluation process. Evaluation includes making the case decision, determining capacity to consent, and activities related to obtaining service authorization either from client or the court. It includes the services of lawyers to represent the agency where court action is necessary to protect the dirt. When an APS petition has been filed, it includes the time until court authorized is obtained. If the needed protective services is not substantiated, referrals to any available and appropriate agencies or community resources are included as though evaluation activities. Documentation of the evaluation of authorization for services of the distributed or required notices, as well as termination of adult protective services in situations where the report is unsubstantiated or services authorization was not obtained or part of the activity. If the case is substantiated and appropriate authorization is obtained, then Code 204 will be opened on the 5027 and used for the day sheets. 204 is mobilization services and means provision of services as part of the service plan when the need for protective services has been substantiated. Such services include arranging for provision of and assessing individuals of their relatives or caregivers and utilizing appropriate services and community resources, conducting quarterly reviews if the case remains open for services, and documenting in the client record and service provided. Includes the services of lawyers to represent the agency where court action is necessary. Includes a case determination decision when the goals and the protective service plans have been met, the client situation has stabilized, and or there is no longer a need for protective services. Also includes time involved in transferring the case for other agency services or additional community services prior to termination. All APS records should contain intake report documentation, documentation of a thorough evaluation in all 6 domains, documentation of a case decision, documentation of notices, documentation of service eligibility, support evaluating records, and collateral documentation. When appropriate, the record should also contain written reports to the DA, DHSR, DMA, documentation of authorization for services or refusal of services, documentation of capacity decision, any court documents, expert evaluation if provided, appropriate notices to the administrator or mental health, notice to guardian if necessary. Let's test your knowledge. Please pause your computer and take this test. After you complete this test, please unpause your computer and I will read each question and provide answers. Number 1. An APS report has 3 different screening criteria. Number 2. You must notify the reporter of the screening decision if they request it. Number 3. The 3 different time frames for screened-in report are immediate, 24, and 72. True/false. You do not have to assess the adult's environment if the allegations was financial exploitation. False. A thorough evaluation includes all 6 domains. A thorough evaluation includes assessment in 6 domains. Number 6. True/false. You must wait until the 30th day or 45th for financial exploitation of your evaluation to make your case decision. False. You can and should make a case decision as soon as you have enough information to do so. Number 7. True/false. If you think an adult lacks capacity, you can go ahead and substantiate your case. False. You must investigate the allegations first, make a case decision to substantiate, and then determine capacity. Number 8. You must make the capacity decision after the case decision. True or false? Number 9. You must alert the district attorney with every report your agency receives. False. You only alert the DA if there is evidence to suggest that abuse, neglect, or exploitation has happened. Number 10, an adult has a fundamental right to refuse services if they have capacity, even if we disagree with their decision. Number 11, you have evaluated an adult who is hoarding. You decide that no one should live this way and you ask your agency attorney to file a protective order. Is this correct step? If not, why? No. We must determine that there is maltreatment, that the adult is disabled, and that the adult needs protection. If they do, they must lack capacity in order to file a protective order. Number 12, true false. An adult can sometimes have capacity in only one area. Absolutely true. True false. Number 13, if you do not have enough information to substantiate, you can do it anyway so the adult can get services. False. Ensure you have conducted a thorough evaluation with collaterals and supporting documentation so that you can appropriately mobilize services. Number 14, a service plan needs goals that are SMART. Number 15, if an adult gives consent for the provision of protective services, they need to sign which document? And there's more than one answer here. 5027, the service plan, and consent accept of services. 16, true or false, a family member are not allowed to assist in service planning development. False. Family and support systems are very critical for mobilization of appropriate services. Number 17, what two forms enable APS to collect data? The 5026 and the 5027. Number 18, MDT is an abbreviation for what as it pertains to APS? Multidisciplinary teams. Number 18, what is the three basic, most standard legal orders that you can obtain for intervention on an adult that lacks capacity? Ex parte, emergency protective order, and protective service order. Number 20, when closing your case, you need to ensure you have addressed which components of the plan for the adult. And there's multiple answers. Resolved risk, address safety, service plan completed, services in place and working, and perpetrator is not a threat. Legal tools AOC forms can be accessed at www.nccourts.org. This is the end of my webinar. I want to thank everyone who has viewed this webinar, and I hope you found this helpful. If you have any questions, you can email the listserv at daas.adultservices@dhhs.nc.gov. Other resources that may be helpful are webinars recorded by Assistant Attorney General Raj that discuss legal aspects and tools in APS. I hope you find this helpful information.